Ming, should we start now or? Okay, sounds great. Hi everyone, and thank you for joining us today. I know that it's morning time in Vietnam, but it's also evening time in Vancouver. So we'll start right on time so that our speakers here can have their evening off in 1 hour. So thank you for joining us here today. And today we're talking about preparing for investor scrutiny and planning your round. Today we have two wonderful guest speakers who are joining us from DLA Piper, Maneesha and Gavyn. And Maneesha and Gavyn, did you want to jump in, introduce yourself, and then I think we are ready to start the session.
Sure, Maneesha, why don't you kick us off, and then I can fill it in and then go on to the presentation from there.
Yeah, sounds great. Hi, everyone. My name is Maneesha. I'm at DLA Piper Canada. I'm in our Vancouver office. I've been working with the spring team now for a couple of years, helping with giving presentations to companies, helping them with kind of setting up their companies to start the round, and looking forward to speaking with all of you this evening and hopefully helping you prepare for your round.
Great, thanks, Maneesha. Hi, everyone. My name is Gavyn Backus. Similar to Maneesha, I'm working out of the Vancouver office here in Canada. I've also worked with Spring, not as long as Maneesha, but on a few matters now. My practice is sort of one of a general commercial nature, but I do have securities specialization, and I often help founders at all stages of their life cycle, whether it's with respect to financings, mergers and acquisitions, or just simply further developing their strategic relationships. So without further ado, I'll kick things off here. As Maneesha, I think, mentioned already, we're going to chat with you for the next hour about the various considerations for companies and founders with respect to raising money. So I see Maneesha has switched the goals here. That's great. Before kicking things off, I'll have to do the standard legal qualification here that, you know, our presentation is for academic purposes only. We aren't providing legal advice on this call, but if you do wish to have legal advice, we do encourage you to reach out and we can chat about that offline. So for today, obviously with any discussion about financing, we're going to have to talk about the dreaded securities laws. I know for both lawyers and clients alike, it's often a very complicated area of law. So we'll touch on a few specifics, but generally keep that overview fairly broad. We'll also touch on general finance instruments and other sort of items to think about when you're preparing for a financing. And then Maneesha will get into more specific timing as well as some general strategy. Next slide, please, Maneesha. So before we kick off, also, I do have the message board here open. So if you do have questions, please feel free to raise your hand or add your message. Either Maneesha or I will chime in. We'll try to respond to it while we're chatting on a free flow basis. Otherwise, if you feel like you want to chat after the fact, please feel free to reach out, or we'll try to reserve a bit of time at the end of our presentation to chat and answer questions. So generally speaking, I think there's a common misconception that Canadian securities laws only apply to public companies, those being companies that trade on stock exchanges. The reality is that whenever a company issues or distributes securities, and they're a Canadian company, or if securities are being issued or distributed to a Canadian, Canadian securities laws are going to apply. And that applies whether or not they're public or whether or not they're private. That's all I'm going to say on the public side of things, because that goes otherwise beyond the scope of what we're going to be discussing today. But on the private side of things, there is unfortunately no general federal securities legislation that governs everything. It's in fact governed by a mosaic of provincial laws, which can often complicate matters. But for our purposes, we're going to, again, keep things fairly broad. The definition of a security, and you'll hear this concept of the security brought up throughout our presentation, is a fairly broad concept. There is, of course, a definition, but we often find it's easier to chat about it on more specific terms by giving examples. So a security, for example, can be a common share, it can be a preferred share, it can be any instrument that's convertible into a share. So for example, options, warrants, restricted share units, or otherwise RSUs, safes, and a variety of other more complicated investment vehicles. In terms of the general broad strokes guidelines or Canadian securities guidelines, basically securities can only be distributed if a prospectus has been filed, prospectus being the governing document that helps a company go public, or if there's otherwise an exemption from prospectus requirements. That's really the bread and butter of private companies. You know, a private company is obviously not going to file a prospectus. So we're going to be just focusing on this concept of there being an exemption available. Next slide, please. So the most common exemption, and you may or may have not heard of it, is the private issuer exemption. Really, without getting into too much of the nitty-gritty of it, to qualify for the private issuer exemption, a company needs to basically meet certain categories. The first of which is it can't be a reporting issuer, meaning it can't have essentially filed and cleared a prospectus to initiate that going public process. It needs to have less than 50 shareholders, which is exclusive of employees and former employees. There needs to be transfer restrictions on its shares, which you'll typically find in the company's constating documents. So their articles, bylaws, shareholders agreements, whatnot. And finally, securities had to have been issued in reliance only on the private issuer exemption. So what does that last category really mean? Next slide, please. So really, when we reference the private issuer exemption, the last list I gave was really how a company can qualify. But this next list provides a set of exemptions that allow investors to qualify to invest in a company. The typical ones that you'll see are directors, officers, employees, right? So if you want to issue securities to a director, they can rely on the director component of the private issuer exemption. Similarly, there's an exemption for close personal friends, current security holders, as well as accredited investors. Next slide, please. Right. So this, I'm always reluctant to sort of bring this up, but I think it is a relevant point. Really, we wanted to focus on the private issuer side of things, but I wanted to highlight one common issue that often arises, not necessarily because clients are trying to rely on the offering memorandum exemption, but often because they might be producing certain investor materials, such as investor presentations or investor decks, that may be inadvertently deemed to be an offering memorandum in the eyes of a Canadian securities regulator. So just briefly, the offering memorandum exemption, like the private issuer exemption, is just one other exemption that a company can rely on to issue securities to investors. This exemption requires that a company produce a document. It's less rigorous than a prospectus. It's not prospectus level disclosure, but again, it is a fairly lengthy document. It does have specific form requirements. It also offers, next slide, please, offers statutory rescission rights to investors and would require that the company file this document with applicable regulators. The reason why I wanted to highlight this, as mentioned, is that if your company, you want to develop an investor presentation to help showcase your business to prospective investors, you want to be very careful about how you develop this presentation and what you include in this presentation. Otherwise, it could be construed by a regulator as an offering memorandum, thereby triggering a bunch of disclosure requirements on your part. So really, our best advice here is to come chat with a lawyer. Maneesha and I would be happy to chat with you about that to really see, if you're staying compliant. Next slide, please. Right. So key investment terms. So a fundamental document is a capitalization table. I'm not, you may or may have not heard this term. You may already know. Apologies if you know fully what a cap table is. I'll try to touch on this fairly briefly and just go over a few highlights. Basically, your cap table is going to outline what your non-diluted capitalization is, being any common shares that are issued and outstanding, or preferred shares or other types of equity, and your fully diluted capitalization being any convertible equity, so options, warrants, RSUs, safes, etc. It's a very important document because it essentially allows investors to sort of look under the hood to see how the company is owned, whether or not founders, for example, have skin in the game. This is often something that a sophisticated investor is going to be interested in seeing. Typically, investors are going to look unfavorably on companies that have a lot of shareholders, a lot of passive investors that aren't actively involved in the company's business, but may own a very large equity percentage of that business. The reason that this can be an issue down the road is because they'll ultimately have a certain level of control over the company, but not actually be involved with the company, and that can create complications down the road. So, we recognize that, again, not one size fits all. And at the end of the day, market trends and market requirements are going to drive how you structure your capitalization table. But we, again, would encourage you to reach out to a lawyer, Maneesha or myself, or any of your other contacts, to help you structure that cap table early on and hopefully highlight any pain points that might arise. Next slide, please. I think this is Maneesha.
Yeah.
Yeah.
Okay, so in addition to the cap table, which is something that a lot of investors will ask for, the other thing they often ask for is a term sheet. So usually when you're getting ready for a raise, kind of first two documents that you think of when you get ready are your cap table and your term sheet. And one of the things that we find helpful is not everyone's really seen what a term sheet is, or maybe your idea of a term sheet is different than somebody else's. So there's some common terminology that's used that we just kind of wanted to explain really quickly. Sorry if it's just a repeat of terminology you already know, but if not, then maybe you'll find this helpful. So the first thing I want to go over is pre-money valuation. So often investors will ask for your valuation, and they'll say, what's your pre-money valuation? Or they'll say, what's your post-money valuation? Pre-money is the value of your company before you get the new capital. Post-money is the value of your company after you get the new capital. So if you're looking for a $5 million investment and your valuation of your company is $10 million, you would have a 10 million pre-money valuation and a 15 million post-money valuation. You don't need to provide both valuations on a term sheet or tell somebody what both valuations are. That's one thing that often sometimes companies do, and it's not necessary because you can kind of figure out one or the other. If you know what your pre-money valuation is and you know how much money you're seeking, then it's very easy for the investor to add the two together and figure out your post-money. And if you have your post-money and they know how much money you're seeking, it's very easy for them to tell what you're valuing your company at prior. So you just use one or the other. You don't use both. The other thing that investors often mention or ask for or talk about, especially early stage investors, is a most favored nation provision. So these investors are coming in early on, they're taking a risk on your company, they're giving you money. So they want to know that later on down the road, when you seek more investment there and you happen to maybe give better terms to those later investors, they can also participate in those better terms. So a common example is like a liquidation preference. So when we say that, that's how much money someone gets if your company is bought or sold. Maybe early on you gave investors like a one-time. So one time's what they invested, they'll get back on a sale. And then later on down the road, you've brought in new investors and you've given them 3 times. Not saying these are numbers you should be using, these are just an example. But so if you give somebody 3 times later on down the road, that early stage investor, because they invested in you so early on and kind of risked your growth in your company, they might say, hey, I want that 3 times as well, and I want the right to choose for that. So that's what a MFN, or most favored nation clause is. Again, if anybody has questions, feel free to just either interrupt or put them in the comment bubble if you have any questions about these terms, and we can go over them in more detail. So some other terms that we see, a right of first refusal, or a ROFR. That's when investors get first dibs on any like potential share sale by founders or other shareholders. So let's say you as a founder are going to be selling your shares. Maybe at this stage, your company is, there's about like 10 different investors. You've decided that you're going to step back and it's going to somebody else. Now someone else is going to take over and grow the company. If you're looking to sell your shares, that investor might want the opportunity to buy them from you first before you go to the public and go to somebody else to buy them. And by public, I mean just another third party, not the actual public market. Another common right is preemptive rights. So another thing is when you raise money early stage, you probably need to raise money again down the road. And you're going to go to more investors or more external investment and ask them to give you some money, and you'll give them equity or securities. So when you do that, often early stage investors want the right to first participate again and perhaps invest the same amount that they've already invested so they retain their ownership percentage. So if I'm an early stage investor and I have 5% of the company and you're going to go do a raise, and if I don't participate, I'll be diluted down to 3%. I may want to participate enough so I can keep my ownership percentage at 5%. That's a preemptive right. The other term that we also hear often is qualified financing. So this is common when we talk about convertible securities. So when we talk about convertible notes, warrants, anything that isn't quite a common or preferred share yet, but has the right to become one. Another instrument, and we're going to get into the instruments more. Another instrument that's common is called a SAFE, and often a SAFE is also triggered by a qualified financing. So a qualified financing is a future equity financing at a certain value or a minimum investment amount that when that happens, those convertible securities will also convert. So if someone has invested in SAFEs, a simple agreement for future equity, and they've given you, say, $10,000, and then you're doing a preferred share round of $1 million, their SAFE might say that once you've done a financing for $1 million, my SAFE also converts into those preferred shares that you're selling people, and I get those preferred shared rights. So that's what we mean by qualified financing. And then 1, 2, 3 times return. So I mentioned that on the previous slide when we talk about a liquidation preference. So that's when, let's say there's a liquidation or there's a sale. So maybe there's a buyout, maybe you were building your company and the end goal was to have it bought by Microsoft. So Microsoft has come in and they're going to buy your company. A lot of your preferred shareholders or early stage investors will have a return on their equity, and it'll be a 1, 2, 3 times return. I'm not sure how familiar everyone is, but at one point in like Silicon Valley, there were some companies that were having like 10 times return valuations, and that's a crazy high number. It's not something that we see anymore. It's much more common to have a 1, 2, 3 times return, but for a while there, I think maybe like Uber and like Twitter were having these massive 1, 2, 3 times amounts. We're going to talk about current market trends later on in the presentation, but just thought I would add that point in right now since we're going over what a return is. A few more things that investors might ask for. So information rights. They might ask to have the right to audited financials, quarterly financials, annual budgets, monthly reports. They just want to keep track of like how the company is doing and how their investment is doing. So it's very common. It's also very common for information rights to be coupled with that right that we talked about before, most favored nation, and MFN. So often an early stage investor will say, if you've given a later stage investor more information than me, I also have the right to that information. So that's one of those rights that might be considered an MFN. Another one that we have is a board seat or an observer seat. So an investor might want the right to nominate a director or sit in on board meetings. I wouldn't recommend giving an investor who has less than 5% a board seat or an observer seat. It's meant for investors who have strategically invested in you. So maybe they have some type of business acumen or they're going to be in an advisory role. So it's helpful for them to come in, or they've invested a lot of money. You don't want to just give everybody a board seat or an observer seat. The other thing to caution about for board seats and observer seats is when you are an early company and let's say you have intellectual property that you want to protect, you want to be careful that you're protecting it properly by having these boards or these observers properly sign agreements before they sit in on meetings. So another reason why you don't just give it to everybody. Fees. Sometimes investors will request that the company covers their fees for legal and accounting advice because they're giving money. So they're going to invest X amount on the company, but of X amount that they invest, it has to go back towards their fees. It's very common for that to be in later stages, not so much in early rounds, but later on when we get to preferred financing rounds, it's very common. It's also common for institutional or angel investors to ask for things like that. And then the last thing that I want to talk about, and I know these are a lot of terms, we understand if you don't remember all of them right off the bat, but it's just helpful to be reminded of what these are, is a secondary. A lot of early stage investors will ask to be part of a secondary down the road. So if someone's invested, let's say at a seed round or a common share round, and we're going to talk more about what these various rounds mean later on in the presentation, but if they've invested early on, they may ask for secondary, which means when there's a future investment by another investor, they're not purchasing securities, new securities from the company, but they're also purchasing some securities from other shareholders. So it's a combination. Typically, when we think of financing, it's new shares, new securities that are coming directly from the company. In a secondary, it's coming from some of the other shareholders. I think we're back to you now, Gav.
Maybe do you want to flag why that might be a preferable term?
As a secondary?
Yeah.
Yeah. Why some investors want that, especially early stage investors, is they want their money back. So if they've invested quite a bit of money in your company, and maybe it was early on and that was, so they were like, yes, I'm fine to give you this amount for now, but I'm going to need some of that back earlier than when you're planning on an exit strategy or a going public transaction. They want a secondary so they can get some of their money back. So it's really common for strategic or like institutional investors to want a secondary. It's also common for founders to sometimes have a secondary. So as a founder, you've put a lot of money into your company and maybe you want to see some of that value of what you've put in and it's starting to grow. You might sell some of your shares in a secondary. The other benefit to having shares in a secondary is it doesn't dilute other shareholders as much. So, you know, if you do have, let's say you've already done a preferred round, so you already have some institutional investors and then you're bringing on some more large investors, those previous investors might not be open to being diluted even more, but they may accept some dilution if it's only a little bit and the rest of the money coming in is because the founders are selling their current shareholdings that they have, or even maybe that investor is going to sell some of theirs.
Perfect, thank you. I think that segues into the next topic here, financial instruments, and I think dilution is a great transition for it. Before I moved on, though, I did want to also flag, apologies, I didn't mention it earlier, appreciating obviously that a lot of the folks, if not all of them, or all of you on this conference call are likely not from Canada. You might be wondering, okay, well, why would Canadian securities laws necessarily apply to me, right? And that's an excellent question. So basically, to reiterate, essentially anytime a Canadian company, so if you are have incorporated a Canadian company and you want that company to issue any form of securities, Canadian securities laws would come into play. Or if you're a company from abroad, let's say in Vietnam, the US, Australia, wherever, and you want to sell securities, shares, options, whatever, to a Canadian resident, then you're going to have to comply with Canadian securities laws. So as you can imagine, things can get quite complicated because if you're a Canadian company, you might have Canadian investors, US investors, investors, other international investors, and ultimately you'll have an obligation to comply with not only the Canadian securities laws, but also the applicable laws of the jurisdiction that the investors are resident in. So with that in mind, we're sort of, I think, at the midway mark. Does anybody have any questions about what I talked about earlier in terms of general securities laws? Or Maneesha did an excellent job, a fairly comprehensive job, so I'm not sure if it invited any additional questions, but we'll obviously have another opportunity to chat at the end, but figured we'd give you the opportunity now while things are fresh. Hearing crickets. Okay. Okay, no questions. That's all good. Maybe the next half we'll invite some further discussion. So financial instruments. Maneesha raised the point about dilution, which is often a very crucial factor in determining what kind of equity you're going to issue. It's not the sole factor, but it is one factor. So, as mentioned earlier, there's tons of different securities that a company can issue. I could talk probably for the next 2 hours, 3 hours about them. I'm not going to, because I think people would fall asleep. So we're going to focus on the 4 that are listed here that are often the most common forms of equity that we see issued by startups or venture capital kind of situations. So common shares, I'm sure most have heard or know about common shares. Obviously, these are your standard shares. They get voting rights. They have other associated rights. Typically, we'll see them issued early on to founders or pre-seed round. The idea here again is control. So we talked earlier about cap tables. Wanting to limit who has control over the company to a select few. So typically you would see common shares issued at the outset, a pre-seed round or founders sort of issuance, or friends and family, something to that effect. I think we can go to the next step.
Yeah.
Yeah. Sorry, thank you. Sorry about that. Now, so that's sort of early stages. Next, you'll sort of see safes, as Maneesha already chatted about safes and convertible debt. They don't necessarily strictly come in that order. Just as a little historical context, convertible debt is sort of the grandfather or grandmother of I guess safes, if you will. A safe came as an alternative to convertible debt to help fast track bridge financing. It came through Y Combinator. I see a few of you, nodding in agreement, so that's always nice to see. So, basically, safes are intended to be a fairly simple document where it's templated, and there's very few terms that are in fact negotiated. You'll have your valuation cap that's negotiated. You may have a discount that's negotiated, financing threshold, and as Maneesha pointed out, a most favored nation clause. And the idea here is to essentially create an investment vehicle for this, pre-seed, seed, bridge round financing. So before you get into your Series A and stuff like that, where you may have already received your investment from friends and family and the founders, but you're not quite in that position to value the company, and you need a cash injection to keep things going and keep forward momentum. The idea also is that a safe is a fairly, it's more risky on the investor side, right? They're getting fairly minimal rights, generally speaking. I'll talk about the exceptions and why safes could sometimes not necessarily be the best option, or they end up just being as complicated as the other forms of securities. But generally speaking, they're fairly risky for investors, but we can get them through and the money into the company fairly quickly because, again, they're fairly templated. Now, in terms of what we actually see in practice, we often see, the use of a safe, agreement. It's fairly templated, but then we see it coupled with what we call a side letter, which is essentially a sort of secondary agreement between the company and the investor that captures a bunch of these additional financing terms that Maneesha spoke about, right? So most favored nation clauses, the right to appoint a board nominee, obligations to produce financial statements, tons of additional stuff, which sort of defeats the purpose, as you can imagine, of the SAFE's original intention to make it a very simple, straightforward document to move through the financing and close and get the money in the door. In fact, we see this so often now that I think Y Combinator actually has a form of side letter that you can download from them. So it's sort of, it's the interesting evolution of how these things work. But that's not to say that it isn't an investment vehicle that's used a ton and that it isn't going to continue to be used. In terms of convertible debt, all right, before I move on, does anyone have any questions about safes? No? Okay, well, if anything comes up, just drop us a note. So convertible debt, as I mentioned, was sort of the original, or for lack of a better term, precursor to safes. Obviously, it's what it sounds like. It is debt. So it's a scenario where you go out and you're going to get a loan from an investor, but then that loan, the principal and or the interest, can be convertible into equity in the company. Typically, we'll see it convertible into common shares, but it can be convertible into pretty much any form of equity. Now, the terms of the note can also change, right? So it can be a very, very simple note, or it can be a debenture form. It can have security. Sometimes we'll see convertible debt that has no interest, right? It's just non-interest bearing, unsecured. And really that will often happen when you see a founder lending money to the company. But when you actually have an arm's length investor coming in, they're typically going to expect to see some sort of interest bearing on it, and they might require security or collateral. The reason why there's sort of been a divergence from, like, we still see this form of equity used a lot, but there's more of a shift towards the use of safes. I think, one, to be honest, because of popularity, but I think there is an added benefit to safes in certain respects where it can simplify the process and expedite the process. But ultimately in Canada, being sort of slightly behind the US often, and then we eventually catch up, we do still see a ton of convertible debt. So, basically those two forms of debt are going to act, as I mentioned, as your bridge financing before you ultimately get to a point where you're going to value the business, or you're going to come in with what Maneesha said, with a qualifying transaction potentially, right? And then at that point, your safes are going to then ultimately convert, and your debt might actually have a triggering mechanism as well associated with it. Finally, we'll talk about preferred equity, only briefly. I think most of you have probably heard about preferred shares. Preferred shares are essentially, they are straight shares, but they'll have special rights associated with them. So whether or not it's a special right to dividends, often you'll also have preferred shares being convertible into common shares upon the occurrence of a specific event. Typically, we'll see that being perhaps a qualifying transaction. So for example, if the company completes a offering of $2 million or more, that would be constitute a qualifying event. That's just a rough number. It could be, of course, anything. Or if the company decides to complete a going public transaction. Similarly, there might also be a convertible event on bankruptcy or dissolution of the company. So ultimately, though, you'll see preference shares, for lack of a better term, being preferred by sophisticated investors coming in these later stage rounds. they want to know and ensure that they have some level of control over their investment. And quite typically, I think, which we'll get into perhaps the next slide. Yeah, sorry, if you can shift over. Quite typically, they'll often require the adoption, if there isn't already one, of a shareholders agreement. So since we're talking about shareholders agreement, I'll jump forward to that, and I'll cycle back to the top of the list, and we can go through it that way. But basically, a shareholders agreement is always, we generally suggest adopting one, whether it's just, there's a set of founders, or whether or not you have a number of shareholders. The benefits of shareholders agreements can sometimes fall a little flat as you get more and more shareholders for obvious reasons. But we like to see it, or I generally see it as the playbook to your relationship with the other owners of the company. So it can be a fairly simple agreement if it's between founders, where it essentially discusses shotgun clauses, or what happens if A, B, and C occurs and I need to sell my shares. Is there, as Maneesha pointed out, a right of first refusal, a preemptive right, whatnot. Where it comes relevant with respect to financings is, particularly a sophisticated investor will likely require that you renegotiate or adopt an entirely new shareholders agreement that contemplates the specific rights that it wants. So this is often something that should be considered while negotiating the investment, while considering the stage of your company, the amount of money that the investor is putting in, as well as sort of other factors. Jumping back up to the top of the list here, I'd like to generally say, and I think Maneesha will get into this later on in the presentation on, I think we talk about due diligence, but yeah, there's an element of credibility that's lent to a company and a founder that really understands the mechanics of appropriately completing a financing or a transaction. It just adds immediate clout. When an investor comes in and they want to look at your documents and it's all even just organized properly, you would not imagine how often we get sporadic emails of documents here and there, and we have to chase down stuff. So I wanted to just highlight that understanding the general deliverables for a financing can really help you through that process in terms of understanding timeline, right? In terms of saying, okay, well, the money's in, why can't we close? Is often the question we get from our clients. And we tell them, well, you don't want to close yet because we need to complete A, B, C, and D. And these are the various reasons why, and these are the risks associated with not doing that. So the list here really contemplates the standard deliverables that you'll typically see as part of a financing. The first is the subscription agreement, or otherwise, your purchase agreement. So that's going to set out the terms of your purchase of the equity or the securities as part of the financing. Typically, it will set out all the specific terms as noted before. So to give you an actual concrete example, a safe would be viewed as your purchase agreement. Excuse me. But that would be coupled with a side letter, which would technically also be part of that purchase agreement. The investor questionnaire speaks to what I talked about earlier with respect to securities compliance. It's really for the benefit of the company. Again, a company wants to make sure that it's compliant with applicable securities laws. The reason being is that if they are not compliant and an investor ultimately complains for whatever reason to the applicable regulator, this can not only put your company under scrutiny, but it can also potentially give the investor the ability to rescind the contract and get its money back. And that can obviously be a big issue if you've already spent the money, particularly if it's a lot of money. So again, we encourage you, even at the early stages, even when raising money from friends and family, you might not specifically need to get an investor questionnaire, but it's always good to keep track of the specific exemptions that you're relying on so that you have a paper record of that going forward. And this looks favorably when you ultimately get to this stage with a sophisticated investor and they ask your company to include a representation or a warranty in the purchase agreement saying, my company has complied, in all material respects with applicable securities laws. And, that's where that comes into play along with a few other scenarios. So we already chatted about shareholders agreements. I'll skip over that. The two remaining items are largely administrative. That's stuff for the lawyers to worry about. But basically, the approving resolutions are, your corporate approvals. They're required for your company to comply with applicable corporate laws in Canada. So it's essentially, the board needs to approve a financing and complete those checks and balances. Ancillary documents, obviously, that's a nebulous term. Maneesha already referenced a few of them. So sometimes you might have no ancillary documents if you're just simply selling securities to your friends and family. You might, that'd be it. But if you end up having a sophisticated investor and as part of their side letter, they've required that you have or that they have a board, not necessarily a board nominee, but what's the word I'm looking for?
Observer.
An observer, thank you. An observer seat on the board. Then you might require, or we'd actually highly recommend that you require that board observer sign a non-disclosure agreement, because they are not going to be subject to the fiduciary obligations that a director otherwise would be required to abide by, but they're still going to be sitting in on all this, on all these meetings where they can hear a bunch of confidential information. So that's just one example. There's obviously tons, and really that's why we encourage you to reach out to your counsel as early as possible so we can discuss, the parameters of the financing and where we might find these pressure points. So I've chatted for a long time. Sorry, Maneesha, I didn't mean to dip into any of your time here, but I'll pass it off to you.
Don't worry about it. Okay, so we're going to, this actually ties in nicely with kind of what Gavyn was explaining on the last few slides, but we're going to talk a little bit about the rounds, I guess, that you would kind of go through when you're looking for investment and what kinds of securities are typical during those stages. It doesn't necessarily mean that this is what's best for your company or what you may do, but this is what's kind of common. So the first round is kind of like your ideas round. A lot of you might be here or in the next round, which is pre-seed. And this is kind of you've got your concept or you've got your market, you've got your product, and you yourself have kind of funded your company to this stage, maybe through loans, maybe you've put in money and taken out shares, and now you're looking to kind of seek investment. And often when people do that, the first kind of round of people they go to, it's called their pre-seed round, and they go to friends and family. So Gavyn just mentioned how when you go to friends and family, you may not be as complicated or whatnot. You know what? I saw some questions, so maybe it's helpful to go through the question before we talk about this. Okay, I will read it out. Question 1, does the SAFE include any provisions to protect the investor against dilution in future financing rounds? And question 2, how is the investor's ownership percentage protected over time? So let's talk about 2 first, just because that's a little bit simpler, and then I'll let Gavyn touch on 1. And so for 2, if we're talking about safes, that's actually one of the things that you may or may not be able to protect. And just generally as an investor, it's not something that you may always be able to protect. So those terms that we talked about, the preemptive rights, that's one way that investors protect their ownership percentage. Before you're allowed to go and issue more securities that could dilute somebody, you have to give them the right to participate and maybe buy as much as they are so they can stay at that same level. Another example is in shareholders agreements that Gavyn had mentioned again. just in the last couple slides. Often in those agreements, there's provisions where investors have to approve future equity issuances, or they have to approve financings if they're below a certain amount, or issuances to certain people. So that's another way that they protect themselves from being diluted. And then for these types of convertible instruments, so safes or notes or warrants, sometimes we have caps on like how much somebody can get. So it's like, it's a bit complicated to kind of talk about on this call. And I think we can, if you have more questions, we're happy to address them later, but we can have like provisions in certain agreements. And this kind of leads to how someone in a safe would protect that. So Gavyn, I don't know if you want to speak about this one, or I can keep talking. Doesn't matter.
Yeah, I can. I think you covered pretty much what I would have said. I just have like a 1 or 2 points to add. So yeah, to Maneesha's point, like there are ways to obviously help, I guess provide anti-dilution rights to investors. To my earlier point, basically within the standard safe format, let's forget about the side letter that comes with the safe. Okay, let's just say the very typical safe format. There isn't really the concept of an anti-dilution right. However, the valuation cap itself does protect slightly against dilution, right? So basically your valuation cap will set the highest permissible value for the company that can be used when converting safes to shares, right? So this would provide essentially a floor for the percentage of the company that the investor is buying. So basically, if you have a valuation cap set at a certain dollar amount, say 5 million, for example, the higher that valuation goes, the more diluted the safe holder is going to be. So the concept of codifying the valuation cap in the safe itself is going to set that threshold. So it doesn't mean that the safe investor won't be diluted, but it will mean that potentially they'll be capped at a specific amount of dilution. Okay. Now, to my earlier point about safes getting overly complicated and then sort of turning into something that they didn't need to be, we will see sometimes anti-dilution rights incorporated into the side letter, right? At which point we're complicating things, and then often as lawyers we question, hey, why did we use the safe to begin with? There was probably another way of doing this that would have been easier, right?
There is a reason why it's called a simple agreement for future equity.
Precisely.
At least it's supposed to be.
Precisely, yeah. So that's what I wanted to add. Otherwise, I think Maneesha covered it excellently.
Awesome. If no more questions on that, perfect. Then we'll keep going with this slide. And if anything else comes up, just feel free to say it or put it in the chat. Okay, so that's ideation. And then we've moved on now to pre-seed. So pre-seed is when you're looking at your friends and family. Maybe you've got some angel investors or some venture capitals investors. This is probably where you're starting to grow. So you need the money to grow. Maybe you have a product or you have beta customers and you're trying to grow it to the next stage so that you can have more revenues to support your growth needs. So at this round, we talk about pre-seed. It's usually something like a safe or a common share. That's very common to use in pre-seed. The reason why you use safes is because you may not have a valuation or you may not have an idea of what you need to raise for your company, but you know that you need some money. So you might have some investors come in with safes with the promise that whenever you do that next round, it's going to convert. Or you might just do common shares at this stage because it's friends and family and they're okay with common shares with minimal rights. Often in the ideation and pre-seed, very little paperwork. Yes, you still need paperwork to make sure it's all done, but you aren't really negotiating shareholders agreements or share terms or dividends or anything like that. Often the pre-seed round is like a take it or leave it around with friends and family. And then we move on to our seed round. So this is like post pre-seed, maybe you've used that money. Maybe now is where you're converting your safes because you have a seed round and it's maybe preferred, like light preferred shares, seed preferred shares, they're often called. Again, you're still growing. You still need a lot of money, but you have more customers now. You have more of a base. Your growth and your company's potential is now attractive to institutional investors or bigger angels. So now you might start negotiating some shareholders agreements, side letters, most favored nation provisions, preemptive rights. Those might start now coming into play because you've got some investors that are more sophisticated and they want to see the company grow. They're not just helping you out because they like you, because they're your best friend or your mom or dad. So that's kind of where we get to our seed round. And then from there, you start to raise more money and you start to get more sophisticated investors and you start to have more sophisticated paperwork. And you may need to go back to investors and you may need to go back to them and negotiate their previous terms in order to bring in more money. So they do get more complex, with kind of like the end being maybe you're targeted by a private equity firm, or venture capitals that are looking for growth, and they're going to take a huge chunk of your company and they're going to have a ton of rights and they're going to want them all, and then they're going to push it to exit. So as we look at this chart and we go from the left to the right, think about it as when you're asking for less money, you're closer to the left, and when you're asking for more money, you start moving towards the right. On the left, it's more company friendly. On the right, it's more investor friendly. More money, investors want more rights. On the left, the founder typically is leading the term. So you're going to people and you're saying, here's what I'm going to give you, take it or leave it. As you get to the right, you are taking what the investors give you. The investors say they want something, you want their money, you kind of give it to them. Again, on the left, not very many special rights for these investors. As we get to the right, lots of special rights, agreements. And then the other thing that might change is the kind of information people get. So on the left, they might start asking for information rights. As we grow, we ask for more money. They'll start asking for observer seats. And then as you get to the end, when you get to that Series B, Series C, those institutional investors, those growth venture capital firms, those private equity firms, they're looking for a board seat. They want to sit in, they want to watch your company grow, they want to have input. We're going to talk about this a little bit more on the next slide, but due diligence. So as we're on the left, less due diligence, on the right, more. They're starting to look at what your company has. They're looking at your paperwork. They're looking at what your other shareholders' rights are. They're really focused on what you say your company has, and they're really focused on the diligence process. Just being conscious of the time here, I'm gonna go through this slide really quickly. So this is kind of what you're looking at in terms of timelines for closing things. If you are doing a pre-seed round, it's very short. Typically it takes about a month because you're doing it on a rolling basis. You've got 1 or 2 investors. It's very small. It's very easy paperwork. So that's like friends and family or early stage investors. And then when we talk about seed, that's like the next round. There's going to be some more diligence. There's going to be some more complex agreements. Closing will take longer, and you might negotiate your term sheet a little bit more. And then when we talk about those like more to the right, so Series A, Series B, Series C, you're looking at a much longer timeline. Your term sheet will take longer to negotiate. Your diligence will take longer to finish. The agreements will take longer to negotiate, and your closing will take more time as well. So just keep that in mind when you're thinking about your equity needs and your financing needs and your cash flows. It's really, really difficult to close an investment in less than a month. You might be able to with pre-seed, but if you're starting to talk to sophisticated investors, expect more of a 4 to 6 month timeline. And one final note, this is just a slide that we made with PowerPoint. It's not the best, but not everything happens at the same time. So you're not closing starting on month 1 to 5. Closing happens just later on. It was just the indication of how many months it takes. So that's that. I think we're going to skip over these valuation slides. It's good to know the value of your company, but I will say that often you don't know, and there's no actual formula to it. A lot of people hire evaluators because they're experts in it. When you are a smaller company, a evaluator is very expensive. So often your valuation is what the investor is willing to pay, or what you can kind of compare yourself to other companies. You don't always need to have a valuation when you're doing a safe. That's not necessary, or when you're even doing an early stage round. Valuations will come in later on when you're dealing with more sophisticated investors. And at that time, you'll have some more information to help back what you think your valuation is, but don't stress about it if you don't have it right away, because a lot of people don't know. You're too early of a concept, and that's totally fine. I think we're planning on sharing these slides, so you can read these, and if you have questions about them, just let us know. I think it might be more helpful to talk about so current market terms, and then maybe just how to set your company up for an investment. So when you are thinking about what you should be offering, what your terms should be, what your financing should look like, it's really helpful to go and look at what other companies that are your size, in your sector, in your area, what they're doing. If they're raising money, what did they do? What were their terms? What's market at that time? Market is constantly changing, and market depends on the space that you're in, the business model that you have, what your equity structure already looks like, and what your growth potential is. So market for everyone is very, very different. When you're starting to look at what kind of terms you should be offering for your financing, it is really helpful to go and look at what other companies are doing. Another thing, and I think everyone's experienced this, but with recent market trends, with inflation and interest hiking to really high rates, the public markets are slower. We're seeing a lot of companies do smaller bridge rounds, and we're seeing a lot more investors be really prudent in their diligence. So they're spending more time to look at companies, to look at their documents, to make sure everything's in order. They're also spending more time putting investor protections in place. So things that protect them. While someone before may have done a safe, or they may have done like a preferred share round, now they might do a convertible note, because a convertible note is still payable in cash because it's debt and not always equity. Whereas with a safe or common shares, you're just getting equity in a company. So if the company ends up not going anywhere, or the valuation drops, you've lost money. With debt, you get your money back, because at the end of the day, it's a loan, and the holder has the option to either convert the loan into shares or get the money back from the company. So we're seeing a lot more investors opt towards convertible debt as opposed to straight equity at this moment. But of course, it always depends on what market you're in and what your company looks like and what others are doing. So there are certain spaces that are not impacted as much as maybe others are. Gavyn, anything you wanted to add in on all of the stuff that I went through really quickly?
No, I think you captured it well. Just being mindful of timing. I'm gonna hold my lips tight here for the remainder until we have questions.
Okay. So here are the next two slides. I think are going to be helpful to everybody here as you're looking to prepare yourself for a raise. You're looking to go out to investors and show them, hey, here's what I've got. Look how attractive my company is. Come invest in me. So you could do a bit of a corporate health check. What do your corporate records look like? Have you properly filed everything? Are you incorporated correctly? Do you have all of your shareholder documents, your directors' documents, your officers' list? Is all of that good to go? Because investors are going to want to see that you're properly organized. Are you keeping up with your annual filings? I don't know how it works when you're incorporated in other jurisdictions. I think many are very similar though, but in Canada and in the US, you have to file every year with your registrar to make sure that your corporation's in good standing. So making sure that you're up to speed on that, We talked about the cap table. Make sure your cap table represents who your actual shareholders are, who your convertible equity holders are. So your stock option holders, your debenture holders, your warrant holders, all of those should be on your cap table. Your stock option plan, if you have one, make sure you've got it documented and all of the options that you've issued are properly documented. If you have a shareholders agreement, make sure everybody signed it. Make sure it's all done. No one's missing. Employment agreements. All employees should have a written agreement. So make sure that those are there. If you are an IP heavy company, so if you really rely on your IP, that's your selling point, make sure the proper confidentiality agreements are in place. If you can make any filings for trademarks or patents or copyright, make sure you've made those filings if it makes sense for the type of IP that you have. Registrations or licenses, if you need a business license to do business in the city that you're in, or any registrations for the kind of industry that you're in, make sure those are up to date. If you have any customer agreements, supplier agreements, make sure they're signed. Nobody wants to see a customer agreement that the customer hasn't signed. Doesn't necessarily mean the customer is then obligated to comply with it. So especially if you're looking for investors and to show them what your sales are, your signed customer agreements are really important. So all of these types of documents, and there's many more, are things that you yourself can just do and have ready to go that will just help your financing process go so much smoother, especially considering how much time investors are putting into diligence right now. The more effort you put in the front to have everything done properly means a quicker diligence process and less of their time spent on diligence. So they're more eager to invest. Did you want to say something, Gavyn?
I was just gonna add, I know I promised I wouldn't say anything, but I was just gonna add that on a practical note, we often, especially now, as Maneesha pointed out, money is more expensive now. It's harder to get investment. Investors are really doing their due diligence. So we have had clients reach out to us to do a preemptive corporate health check. So not only has the client evaluated on a broad strokes basis, what's going on under the hood, so to speak, but they've actually retained their lawyers, being us, to look at all the documents on a more granular level and point out issues that we would suggest correcting, or areas that might be a hindrance to a possible financing or a possible transaction.
Yeah, yes, that's something we commonly do. And this kind of touches on that as well. The VDR, so your virtual data room, the way that you're sharing documents with investors. So depending on the level of investment you're seeking and how sophisticated your investor is, again, if you're doing a friends and family round, they're probably not going to ask you for documents. But as soon as you start going to private equity firms or venture capitalists or angel investors, they're going to want to see the documents and you're going to need to find a way to share them. A common way to do that is a data room. So whether it's on Google, Dropbox, any other platform. Not that I love some of those platforms, but it's all fine. You're sharing the documents. There's ways that you can make the VDR be organized in a way to make the diligence go faster and provide the information quickly and efficiently. So the best way to do it is start early. If you already know that you're seeking investment, put in a folder that has all of your corporate organizational documents, label it, date it, make sure the names of all the documents are easy to read. If you have employment agreements, put up a folder with employment agreements. Very easy to kind of get those things started. And then if you see gaps, if you see documents that are missing or unsigned, work to fill those gaps, work to get those documents done. Organize by folders and subfolders. It's really difficult for people to go through a data room and just have a bunch of documents that are not organized. It takes them twice the amount of time to kind of figure out where everything is. So if you've preemptively done that, it makes the investor's diligence process so much easier. It makes their lawyer's process quicker, so they're spending less money on legal fees. They'll be happy. Make sure the information's current. If you have expired agreements or old corporate records, you don't need to put old things that no longer apply in there, just put in the current information. So shareholders agreements that no longer apply don't need to be in there. Employees who have left don't need to be in there. Contracts that have expired, those don't need to be in there. So keep your data room up to date, especially if you're using the same data room and you're just going to update it for future rounds. Just make sure you're also checking to remove outdated information. If an investor gives you a list of documents, it's helpful to cross-reference their list. So you can send back a note and say, okay, here's your sections of what you asked for. You can find these documents in this folder, this one, and this one, this one, and this one. It's funny to say this, but make sure that you have some type of security on your data room. Don't just make it an open link that anybody who has the link can use. People forward emails all the time. Links are shared. You want to make sure that this confidential information about your company is only going to the people that you want it to go to. And also, if you're sharing it with multiple investors, you want to make sure that each investor can't see that the other investor has access to the folder, especially if it's competing investors. So maybe it's one or the other, or you went to one and it didn't work out and now you're going to another one. They may not like to see that you have an investor that's a competitor also looking at your company. So make sure that you have some type of security, password protection, and that you're not sharing the data room with everyone. Have one person be in control. So one person is uploading, responding to requests, making sure the data room's running, coordinating with the investor. It makes it cleaner, it makes it more efficient, and it just helps you not waste resources as well. It does take a long time to go through diligence, and you're also trying to run your business and operate your company. So it does become a bit of a big use of your time if you're not organized, or if you don't have one person doing it, and it takes you away from actually operating your company, which is more important. And then don't give people access to your own internal filing system either. Make sure it's a brand new folder meant for diligence. Again, this kind of goes with the whole idea of making sure it's password protected and secured, but you don't just want to give somebody access to your own internal Google Drive that you maybe share with you and your co-founder. You have confidential information in there that probably shouldn't go to them, and you want to be able to remove people from things afterwards. So if it's its own separate data room that you can just shut down, much easier than trying to remove somebody's access and not accidentally doing it. And those are kind of your BDR strategies. I know we kind of ran through those last few slides, but we will circulate them. And they're really more just tips on ways to be prepared. So if you do have questions, we're always happy to answer them. If you send us an email, or if you want to set up a call, that's no problem. Or if you have some right now, we're happy to answer them if you still have time.
It's such a good job of covering everything, Maneesha. No questions.
Yeah,
I feel like in everyone's mind is like running through all of the information. They're trying to process it.
It is a lot of new information. So we understand if maybe you take a look at the presentation or you rewatch the recording and then a question comes to mind. Of course, if we're able to answer it, we are more than happy to. So just send us an email, and you can do that. Our emails are also on the slides. So that's mine and then Gavyn's. So.
It's such a great job. I think it is a kind of very intensive hour for us as an audience. There are several questions, but I think the convertible loans is quite new concept here in Vietnamese market. So there are several questions related to this. I'll just prepare it before. So what are the normal terms for repayment if the loan is not converted? And is there any option for early repayment sometime?
Yeah. So the terms of the loan are actually really dependent on what the investor and the company negotiate. I've seen all different types of repayment provisions, but I would say some common ones are a loan. So a loan might have a maturity date of, I'd say it's common to see 2 to 5 years of a convertible loan. I'd say it's more on the 2 to 3 year side than the 5 year side. Investors don't really want to wait that long to be paid. But that's kind of the time, that's kind of what I've seen as market. And then if at that time, the company, often there's a repayment right without any penalties. I've seen that as well. And then if the company hasn't paid by the maturity date, it's usually up the option of the lender, whether or not they want to convert into securities or request repayment. But I've seen it also just be at the election of the company. And I've seen it be an automatic conversion at maturity as well. So all of them are common provisions. It really just depends on at the time how badly the company needs the money, that what terms are they willing to accept, and how eager the investor is to invest.
Yeah, interest rate would be similar as well. You know, it will range, of course. In Canada, there is a cap on how high interest can in fact be. There's a criminal rate, so which is what, it's like 80% or 60%.
It's very high.
It's extremely high, but the way that it's calculated, sometimes if you have annual interest compounding in such a way, sometimes we have seen it come quite close. So you want to recognize too if there's a similar restriction locally in your jurisdiction, but otherwise interest rates also going to come into play, right? So if it's a shorter term loan, you're probably going to have a higher interest rate.
Any case, in some cases that our startup from Vietnam might want to reach out to Canadian market, is that possible for them to connect you and ask for your service, if any? Some of them really want to set up a business in Canada. Yep.
That's what we're here for.
Okay.
We do that.
We're very happy to introduce you.
Yeah.
Yeah,
absolutely.
The embassy is very much interested to see that there are, names of the loyal company from Canadian on the list. Yeah, so it could be really great, useful that we put you on the list to introduce to Vietnamese startup. Thank you very much for today.
Thank you.
Anytime.
Thank you.
It was our
Okay.
pleasure.
Sorry, just wanted to say, do feel free to share with the participants Maneesha's and Gavyn's email, so that later on, if they needed to contact them, then they can do that.
For sure. Thank you.
Can I have the presentation, because that's really a lot of information.
We will.
Yeah, we'll send out the presentation later on this evening or tomorrow, and then you'll have it. You can share it as well.
Yeah, I need to read it again with my note and.
Yeah. And our emails will be on there as well, so you can have all the information.
Thank you.
Thank you very much for today. Yeah.
Thank you so much, Maneesha and Gavyn, and thank you everyone for joining us today.
Okay.
Thank
you.
you.
Have a good night and have a great day.
Yeah.
Bye-bye.
Bye-bye.
See ya.